Is this speaker on? Making you happy?
Yeah.
Okay. Well, thank you all for coming tonight. I am John Eckstein. I'm a lawyer from Fairfield and Woods, and I've been practicing law for 40 years. I'm a corporate finance and securities lawyer. I used to be a solo practitioner for a while. I worked with a lot of startups, and we were just talking about the Licensing Executive Society. And when I was a solo practitioner, I was the president of the Colorado chapter of the Licensing Executive Society, which is a group organized around a type of a contract. So if you own a patent and you don't want to sell the patent or assign it to someone, you might want to license the right to make things, have made, use, or sell something using the patent, and that contract is called a license. I'm not going to talk any more about that today, but it's a useful type of contract, and the people who are involved in that organization, they're restarting that chapter, by the way, so I'm going to promote the Licensing Executive Society, although I'm not a member anymore. But here tonight, we're going to talk about small company financing, or basically any kind of financing using the internet or social media, where we're selling something called a security. Oh, I should also say I'm with the law firm of Fairfield and Woods. Fairfield and Woods is a Denver-based law firm, about 45 lawyers. We've been here since 1934, and we have corporate, we have real estate, we have litigation, we have estate planners who do wills and trusts and things. We do not do patent, but we do copyright, trademark, trade names, and licensing, you can see. And Fairfield and Woods is happy I give these talks so that people might hire us sometimes. So think good of Fairfield and Woods. I know some of you have heard me talk before, at least three of you. So, but I'm just going to start off with a little bit about the securities laws. That will just give you the background. Okay. So, a security is any passive ownership interest in a profit-making enterprise that someone else is going to run, basically. So, orange groves. If you invested in a partnership that owned a bunch of orange groves and you expected to get money out of the operations of the orange groves, you bought a security. If you buy stock in IBM, you bought a security. Some securities are promissory notes or convertible notes. So if you loan money to a guy to start up a business, you probably got a security there. Okay, it's a very broad definition. In the United States since 1933, there's been a comprehensive plan or scheme to regulate the purchase and sale of securities. It's called the Securities Act of 1933. And then there's also a law in 1934 that dealt with broker-dealers and aftermarket trading in securities. Like when I go down to Merrill Lynch to buy 100 shares of IBM, that's a regulated transaction, aftermarket trading. Then there are two other laws, the 1940 Investment Advisors Act and the 1940 Investment Company Act. And all four of these acts are relevant to what I'm going to talk about tonight. I've given you my handout. I'm not using PowerPoint, but there are a couple articles on our law firm's website that describe what I've just said in much more detail, and also basically everything I'm going to say tonight is in one of these two articles. And they're on page 16 of your handout. There's a reference to the URL, and you can go to the articles online on your own, take a look at them. So going back to where we are, the comprehensive scheme of regulation basically says every purchase and sale of a security in the United States must be registered with the Federal Securities and Exchange Commission unless there's an exemption from registration. And every purchase and sale of securities in the state of Colorado, for example, has to be registered with our state securities commissioner unless there's an exemption. So there are many exemptions, and you go to securities lawyers to find out what those exemptions are and how you can use them in what you're trying to accomplish in funding your business. The biggest, there have been many regulations written since 1933, and increasing the amount of regulation of the purchase and sale of securities at the federal level and the state level. And all of a sudden, this act came along called the Jobs Act, which deregulated, which reduced the amount of regulation, and basically brought us into the 20th century, if not the 21st century, in securities laws. And I'm going to talk a little bit tonight, mostly about how to raise money using the internet and social media and under the Jobs Act, because that's basically what's driving all the new things that are going on. And I didn't know how to start off by making it relevant to the folks in the audience, but about 2 hours ago I got an email out of the blue from someone called Marvin Bishop in Amarillo, Texas. Got through the spam filter. It says, need help with financing my invention, the Infinity Electric Reactor, a self-propulsion electric generator I'd like to install in every American home. Okay. And then it goes on, it says, send $1 to sponsor this invention. And then it says, your dollar will be reimbursed to you 100-fold every month for 5 years. Okay? This guy is probably violating several laws. Okay? Yeah. Well, it just showed up. I've gotten it before and just deleted it. I mean, there's advertising. I mean, this is not the way to do it right, okay? On the other hand, I think he is selling a security because he's selling a return on a passive investment that he gets the money in the use of, and he's the one who's going to give you the returns. So for $1, you'll get $100 every month for 5 years. So that's 60 times 100. That's how much money you get back if you give him $1. Don't send him $1. I'm not telling you to do that. And I don't think he had the benefit of a lawyer when he did this. I think he might have, he's got YouTube, he's got Wikipedia, he's got Da Vinci Inventions, but there's the right and the wrong way to use the internet. This is not the right way. Okay. So I'll just put that on the altar here. Pray for forgiveness for Marvin Bishop. Last name, very useful. Okay. So I do have this, and I should also define the term. How many people know what an accredited investor is? Could you raise your hands? Accredited. Okay. Let me just explain for those who don't. The Securities and Exchange Commission came up in 1982 with the definition of an accredited investor. And what they did with that was to separate among natural persons those who were accredited and those who were not. And their assumption was that those who were accredited investors could fend for themselves and didn't need to be protected from unscrupulous people selling securities as much as unaccredited investors. So under the rules in 1982, which still exist today, for a natural person, what is an accredited investor? An accredited investor is a person who made $200,000 in basically adjusted gross income last year and the year before, and reasonably expects to make $200,000 this year. Or if it's investing husband and wife, $300,000. Okay, so $300 2 years ago, $300 last year, and you expect to make $300 this year. Or have a net worth of at least $1 million. Okay. Now this did change under an act called Dodd-Frank about 4 years ago, and they took the value of the house out of the net worth calculation. So it's $1 million now without counting your house with a positive equity. But if you are underwater and have negative equity, they have to count the negative equity. So if the house is positive value, you don't count it towards the 1 million. So an accredited investor, natural person, 200,000 a year for each of the last 3 years, or worth $1 million, not counting the house. Okay, that is going to change. This is a footnote; it's not in this, but the Dodd-Frank Act, which passed in 2010, which is not in this, I'm not going to talk about, created a committee called the Investor Advisory Committee, and it was instructed to come up with changes in the definition of accredited investor. And on October 30th, they had a report that came out of what they're recommending to the SEC, and everybody expects them to be raising those limits. Okay, the point is that in 1982, the definition of an accredited investor, if it was $1 million then, if you adjust for inflation, it would be $2.5 million today. And if it was $200,000 then, it would be just under $500,000 today. So everyone is expecting it to go up here pretty soon, and that will eliminate about, according to the Angel Capital Association, about 38% of all accredited investors today will not be accredited if they raise those limits, those minimums, okay? There were 7.2 million families, households, that could meet one or the other of the criteria in 2010, okay? So that'll go down by 38%, okay? So the only point there is that it's going to change. Now, it may take a long time to change, a year or two, but Congress wants it to change. Okay, that's enough on that. Okay, you with me so far? I haven't even started the outline yet. Okay, so and there's also another concept besides accredited investor, the concept of preemption. There are certain federal laws where if they are enacted properly, preempt the states from regulating in the same place. So, remember I said there's a federal, has to be registered unless it's exempt, and Colorado, his state has to be registered unless it's exempt. Sometimes, and we'll talk about this, the federal exemption, the special exemption, preempts the states. So if you get you satisfy the federal exemption, you don't have to worry about the state of Colorado. I mean, you might have to do a filing, but that's all. We'll talk about some of that in here, and it does drive which exemptions people use when they're talking about selling securities online. So let's just turn to page 2, and just about the Jobs Act. It was signed by President Obama April 5th, 2012. The SEC didn't want to do it, but Congress did it anyway. Senator Michael Bennet said it's time to get it done. And so one of the very few things that the Congress, it's almost over. And it's over on, your Congress runs up until like December 12th this year, and then there'll be a new Congress in January, the one we just elected. Okay. And one of the few things they did was actually enact this Jobs Act, which is a big reduction in regulation. Okay? Just to be complete, it had 7 titles. The first title deals with initial public offerings, registration, selling stock to thousands of people. And it's working very well. It was self-executing, and I'm not going to talk any more about that. It's for bigger companies. Access to capital for job creators is 506C, and we're going to talk a lot about that later on in here. Title III is crowdfunding, or what people call equity crowdfunding, and we'll talk a little bit about that too. But the word crowdfunding is being used so often now that you really need to sort of put it out of your mind. You don't know what they're talking about when they say crowdfunding. All you know is they're selling on the internet. You need to dig deeper to find out exactly what they mean when they say crowdfunding. Title IV, the small company capital formation, that is setting up a new exemption called Regulation A+, or it's going to be called Reg A Tier 2. And I won't talk any more about it, but it's basically a limited public offering up to $50 million. And for purposes of this conversation, we won't talk about it anymore. Title V has to do with registering under the 1934 Act. You don't need to worry about that. It's the aftermarket trading, and when you do exempt offerings, you don't get enough stock out there to be registered under the 34 Act. Title VI and VII we'll just forget about. They don't have any. VI had to do with banks, and VII had to do with let's make sure we include women and traditionally underrepresented minorities when we write these regulations. So I want to focus in on Title II and Title III. Title II deals with this exemption called Rule 506. Before the Jobs Act came along, there's a self-executing exemption called Section 4A2 of the 1933 Act. That means a private placements. So if you do a private placement, according to what the courts have said a private placement is, you'll be exempt from registration. Good. People wanted to know what does it all mean, because they don't understand. Everybody has the time to go out there and research all the court cases. So the SEC came up with a safe harbor, which they call Rule 506. Okay. So SEC Rule 506 before the Jobs Act basically said that you can sell securities to an unlimited number of accredited investors for any number of dollars, as long as you put restrictions on resale, a couple other things, I'm going to sneeze, and you didn't do general advertising and general solicitation. So, and you had to take steps to modify, okay, fair enough. So no general advertising, no general solicitation under Rule 506 before the Jobs Act. What the Jobs Act did was say that the SEC has to modify that rule to say that if you take steps to verify accredited status, if you sell only to accredited investors, then you can do general advertising and general solicitation. That's what the statute said that they passed, that President Obama signed April 5th, 2012. And just on page 4, a little bit more of what was in the statute. Excuse me. They went on to say that if you used a broker-dealer, that's a person who's licensed or exempt from being licensed under the 1934 Act for aftermarket trading, or if you use a platform, or if you go with a co-investor, so a co-investor is bringing in all the other people, or if you go with someone providing certain kinds of ancillary services, those are investors, then they won't be broker-dealers. You don't want to be a broker-dealer because that requires you to go get registered or go through all that 1934 Act stuff. So either be a broker-dealer, or you can be a platform, or you can be a sort of a bundler, and that's on page 4. That's in the statute. The platforms are the ones you want to focus on, because that's you see a lot of platforms out there now. This is still under the statute. I haven't talked about the regs yet, but there are certain rules about what a platform can be. So on page 5, I say you can't receive compensation in connection with the sales of the securities. So no commissions if you run the platform. You don't take possession of money or securities, and you're not subject to statutory disqualification. It basically says you're not a bad boy, and there's a long list of people who violate securities laws who've been enjoying, people who've done jail time for certain kinds of things, people who've violated federal postal service regulations. Those people are subject to statutory disqualification. Remember I said I'd also talk about Title III, equity crowdfunding. I'm not going to talk very much about it because, as you will see in a second, it's very complicated and it's a lot of work for very little money. Okay. But basically the statute, there's 6 pages of the statute, I brought the statute along, that defines this exemption, but still has to have additional regulations that are written by the SEC. And we'll see that those have been proposed, but they are not final yet. So you really can't do equity crowdfunding yet. On the SEC website, it says equity crowdfunding is still illegal for the SEC. So no one who says they're doing crowdfunding legally is doing it under Title III of the Jobs Act yet. Okay. When they get around to being able to do it, the statute requires, among other things, looking on page 6 here, the most an issuer can sell is $1 million worth of securities in a 12-month period. The most you can sell to an individual is $2,000, or 5% of the annual income or net worth of the investor, whichever is greater, assuming the annual income is less than $100,000, or 10% of the annual income and net worth of the investor, not to exceed a maximum aggregate amount of $100,000. A lot of calculation that has to go on here, as it's going to be very hard for the issuers to tell who's put how much in. You're really going intrusive on this, okay? The transaction has to go through a broker or a funding portal, okay? Foreign issuers can't use it. There are a lot of other requirements, like SEC filings, record-keeping, disclosure, and you have to have accountants have to get in there to help out. It's just a lot of work under the statute. Let's just talk a little bit about the status of the rulemakings, the SEC rules that have to be done, and you'll see where we are. It's on page 7. So as I said, Title I, which we're not going to talk much about, that was pretty much self-executing. The SEC, that was for the big companies going IPO, and the SEC, didn't write any regulations for that. It just worked because it was in the statute. Title II, the final regulations for 506 general advertising, general solicitation went into force on September 23rd, 2013. Title III, that's the equity crowdfunding. They're still proposed regs. They were proposed October 23rd. Title IV, which is that Reg A plus stuff I talked about, that's still proposed. And the reason that's proposed is the states are fighting it because that was another preemption. Remember I said it went up to $50 million? The state securities commissioners don't want to be preempted from reviewing and stopping, if they don't like them, semi-public offerings to residents of their states. So there's a fight between the SEC and the states about that one. That's why they're not final. And the other ones, which we're not going to talk about, are self-enacting. So let's go to the regulations. On page 8, the SEC adopted the new regs for 506C. 506C is the general advertising, general solicitation, sales to accredited investors only, okay? The new rule eliminates prohibition against general advertising and general solicitation, and it became effective on September 23rd, which is basically 60 days after it was published in the Federal Register. Page 9, the details of the exemption as fleshed out by the SEC. All the purchasers, must be accredited investors, or the issuer must reasonably believe that they are accredited at the time of sale. The issuer must take reasonable steps to verify that they're accredited, and then the other rules that applied to 506 as it used to exist still apply. So reasonable steps to verify is important. Let's just take a peek. Next page, 10. How to verify. So an issuer, remember an issuer is anybody who's raising the money basically for its own use from passive investors who aren't going to be involved in the operating of the thing. The issuer should take an objective, principle-based approach, considering the facts and circumstances of each purchaser and each transaction. And here are what they're supposed to look at. Well, people complained and said, look, how do we really know? So once again, the SEC came up with a safe harbor. Those are on page 11. How to verify accreditation, safe harbors for individuals. So there's an income safe harbor. There's a net worth safe harbor. There's a safe harbor if you can get a letter from a broker-dealer, investment advisor, attorney, or accountant. And also if you'd invested in a deal before the effective date and the same issuer wanted you to invest again, the issuer could presume that you are still accredited for purposes of that, okay? Now, income, you can see the types of things that give you the safe harbor. Remember, income, we're talking about the $200,000 or the $300,000. So they'll accept tax returns, W-2s, 1099s, 1040s, basically. For net worth, that's the $1 million, not counting the home. Brokerage and banking statements, personal financial statements, things like that. Our law firm has only written one written representation for a very, very wealthy person, okay, since this came into effect. So I don't know, because it's not, lawyers don't like to do this, accountants don't like to do this, because it's just a fact statement. The guy's worth $1 million. But how do I know everything? And it's just facts. It's not a legal opinion. It's just facts. You know, so the professional broker-dealer might do it if they have $1 billion under management for George Soros. I'm sure they will. So anyway, there are these safe harbors under 506C. So, you know, general advertising, general solicitation would be, for example, and we'll get around to some of this. So you send an email out to 1,000 people, you know, and then they turn around and they respond that they are interested. And then you, as an issuer, you send out the questionnaire. Are you an accredited investor? Question, 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 question. It comes back. Self-verification is not enough. So you have to independently, under your system of verification, do something that leads to the conclusion that the guy is what he says he is, a millionaire, okay? And I tell people, Google him. And I mean, that's good enough, but you got to have a routine and a system to do it. If you do not have a routine, the reasonable steps routine, even if the guy turns out to be accredited and you didn't verify it, you will lose the exemption. Facts are not relevant, yes.
Question, if I do a 506 solicitation of just accredited, the verification and accreditation is a separate issue, but do I have to file any form with the SEC?
Yeah, well, it's the same. A 506C exemption is treated like a 506B exemption. To save those exemptions, to document those exemptions, you file a Form D, okay? Right now, you file a Form D within 15 days after the first sale. We're going to, in fact, if you look at page 12, you'll see that there are proposed new rules for Form D, okay?
I filed that form.
Yeah.
Mm-hmm. Then am I done with the SEC?
Well, you always have the risk of being sued for 10b-5 securities fraud. So even though you have an exemption, you've got to have done a disclosure of all the material facts that a reasonable investor needs to make an informed decision. So in theory, you could say, if you give me the money, I'm going to Mexico. So that's disclosure. Okay. Well, there are limits to what even if disclosure is permitted. So that would probably not be good. You have to be putting it into the business you say you're going to be putting it into and things like that. So you've always got the risk of being sued for fraud, okay? But having an exemption is pretty key. Remember, the reason you want accredited investors is because if you're selling under 506B to unaccredited investors, but you can't do general advertising. This is called quiet 506, the 506B. There's a specific list of what you have to tell the people if they're not millionaires, if they didn't make $200,000 a year for each of the last 3 years. And so you want to get to the accredited level so you don't have to do this checklist type of disclosures. But I did want to talk about these proposed new rules because they're not final yet either. And that's partly what's limiting the use of 506C is that there are these proposed additional rules, and this will confuse the issue, but the SEC has called this 506 parens B close parens is the old quiet 506. 506 parens C close parens is the new general advertising 506 exemption. They call these proposed rules for Form D Rule 506 capital C. So I've got to say capital C and no parentheses for you to know that difference. Anyway, you can see on page 12, there would be additional uses of the form and more filings if you're going to do this 506C offering. Part of it is that they would want you to give your written general solicitation materials to the SEC the first day you use them. And you'd have to file the Form D 2 weeks in advance. So your competition's going to know that you're going to go out to raise money in a general advertising. Plus, they can in theory, they can go look at your written solicitation materials. And so a lot of people are thinking this, that's why they're fighting this. That's why these aren't final yet. People don't think there's too many filings and too much red tape. Let's go on a little bit more. 13. So where have we come since September 23rd of 2013? This exemption has been dramatically underutilized, 506C. Since September 23rd, well, let's see, the first 6 months, there were 900 new offerings and they raised $10 billion. But most of that was private funds, like hedge funds and private equity. And that's just a drop in the bucket. That's so small because they raised, under 506B in 2012, $1.2 trillion was raised under 506B, and the quiet one, okay? And here they've only got $10 billion out of the one where you can do general advertising, general solicitation. So it really hasn't caught on yet. Okay? We're going to see in a bit that it is catching on in a different way than the SEC thought it would, though. But anyway, this, as I said, the Form D proposal, this thing about 506 capital C, is slowing issuer enthusiasm down. Okay. You sticking with me? Okay. Page 14 is something coming out of left field from the Dodd-Frank Act that all of a sudden applies to 506. I need to mention a couple things. 506B, quiet 506, is the old one where you couldn't general advertise, but you could bring in people who are not accredited. 506C, remember, is the new version that you can do general advertising, but only to accredited. 506D comes out of Dodd-Frank and basically said, if you're going to use 506 in any way, shape, or form, Congress said, bad actors can't use it. Okay? So they finally came out with the same rules effective on the same day under a statute from 2010 to match up with these that came out under the Jobs Act that came out in 2012. And basically what they're saying is bad boys, bad people can't use these exemptions. So here it shows what some of the disqualifying events are. If you have a criminal conviction related to securities within the last 10 years, you can't use 506, the quiet one, or the general advertising. Court injunctions, restraining orders, final orders from self-regulatory organizations like FINRA, what used to be called NASD, or the Municipal Securities Rulemaking Board is a self-regulatory organization. New York Stock Exchange is a self-regulatory organization. Certain SEC disciplinary orders. In any event, certain kinds of people cannot use these exemptions. Okay. So a little bit more about equity crowdfunding, which, remember, the one that's still illegal, that the regs aren't final yet. Here on page 15, you can see they put out the proposed rules, okay? But I thought it's all sort of summed up in this Brian Korn's quote from Forbes magazine. To produce an offering disclosure document and list a funding portal, run background checks, and file an annual report with the SEC year after year. This is somebody who's doing an equity crowdfunding deal. Might well cost upwards of $100,000. Remember, the most they can raise is $1 million. Okay. The high expenses compared to the low maximum amounts that can be raised by a company and invested by an individual. Remember the 2%, $2,000, 2%, 5%, 10% stuff. Okay. And invested by make public equity crowdfunding one of the costliest forms of legal capital raising. So, and that's what I think. I've given this talk to maybe 10 accounting firms or something.
Was that like the $1 million limit on
Yeah.
equity raise?
Yeah.
So we're at 10%.
Well, at least 10%. This is year after year, some of this stuff, because annual reporting with this, it's just a bucket of worms. And for a professional like a lawyer or an accounting firm or a broker-dealer to get involved in this, you know you're going to get sued. It's just a question of when, because everybody's going to be cutting corners to save money. I mean, it's just not a... They needed to fix it. But first, my belief is we will run all these other methods, or we're going to go through all this list of things like general advertising using 506C and other things, and eventually they'll get around to cleaning this one up by statute. They have to do it by statute. But right now, it's just not... I mean, guys get frustrated like Mr. Bishop and send out things because that's who should have been helped by equity crowdfunding, but wasn't. So just the SEC is in no rush to finalize. I put down end of fall 2014, so that's December 21st. I don't know if it's going to come by then or not. Okay. 12 states have enacted their own brands, so we'll talk a little bit about that, their own types of crowdfunding. So there's page 16, that's my questions more in those articles. Then issues and strategies discussion. Now look at page 18. And this is really what we want to talk about today. So, what's going on right now is the SEC is realizing it cannot regulate the issuers, the people who are trying to raise the money for their own use. But what they are trying to do is regulate the intermediaries, the people who run the platforms, the broker-dealers, the people who put up the website for you. That's where the SEC is trying to regulate. So here I've tried to make a list of things, of different approaches to use. Kickstarter, Indiegogo, and Rocket Hub, and other sites like that, those are not, you're not selling securities there. So I don't really know much about that. I have clients who go on Kickstarter. My perception is that Kickstarter, Indiegogo, Rocket Hub, they're not as effective as they used to be. They're just not working, for a 10% discount coupon to buy some item isn't as cool as it used to be. It's hard to get attention. There's so many people out there doing Kickstarter. But it's certainly doable. The things you need to worry about in there are the sweepstakes rules at the FTC and at the state level, or lottery rules, because a lot of people and Kickstarter and Indiegogo don't regulate very much. They have a way of, has anybody ever done a Kickstarter campaign? No. It's just, you can do them. I mean, they do them, but they're just, you have to run it the way that they set it up. And they have a set of rules, but they don't always enforce all their own rules. Anyway.
If I'm doing Kickstarter, it seems like I'm either selling a product for the future,
Yeah.
or just taking a pure donation,
Sure.
or maybe giving a T-shirt I have.
Sure.
So how do people get in trouble, like maybe making it a sweepstakes, like having a contest?
I'm not a sweepstakes guy. Yeah. But there are state rules and FTC rules. You just got to know. And if you're doing loans, there are some loan sites that are not involved securities But those are definitely getting regulated by outfits like the Consumer Finance Protection Bureau. I was looking at those things. Consumer Finance Protection Bureau, that came out under Dodd-Frank. My daughter works at the Consumer Finance Protection Bureau, so I didn't know they were getting into this, but they are. But all the other ones in my bullets here are the sale of securities. They're all different kinds of exemptions. So let's just talk a little bit about them. So 506C is the general advertising, general solicitation that's under the Jobs Act, Title II. Remember, you have to take reasonable steps to verify their accredited status. Sell only to accredited investors. And you can have those safe harbors about income or net worth or get a lawyer to write a letter or a prior investor. And you can do it your own, do it yourself. We'll get back to that. You can do it by, you can do a 506 offering like that, C offering like that, by going through a broker-dealer or a funding portal. Okay, if you do it on your own, you typically would have you would give people a password, and you would qualify them as accredited investors before they got the questionnaires and things, before they got in to look at the offering documents, accept the offer right there, okay, under 506C. 506C offering broker-dealer or funding portal, there are broker-dealers out there. Circle Up, if you look at Circle Up, that's definitely a broker-dealer website. You can do 506C offerings on that site. It's a pretty good site. It started off as an equity crowdfunding portal, and then they realized that the SEC hated equity crowdfunding, and they were never going to be survived, so they converted themselves into a broker-dealer and got funded by, that website is good for consumable products like power bars and things like, natural foods and things like that. It's a good site. I don't know. But I mean, I'm an accredited investor, so I dig deep into these sites on my own. If someone points me in that, there are hundreds and hundreds of sites. So I've got a client, I sent a client over to Circle Up the other day. So go use Circle Up, because he has an energy drink, okay, frozen energy drink. Or there could be a funding portal. We talked about funding portals. That's what's in the exemption, remember? If you don't take a fee, a commission, if you don't take, you don't take possession of cash or don't take possession of stock, it's back on page 4, okay? Those are the platforms that we're talking about, funding portals. I wrote down the name. And there are subscription models of funding portals. There was a website I went into before this became effective. One of my clients asked me what it was about. So I sort of dug in there, dug all the way down, and then I found out that what they were really doing was just collecting the names of accredited investors. They weren't matching you up with anybody. And then the regs came out, and then all of a sudden, everybody coming at me wanting me to buy because I'm an accredited investor. So because I will go to these websites, then I get buried with emails, and I don't have to unsubscribe all over the place to make it stop. But they were a funding portal, building up lists of accredited investor only to be able to do 506C offerings. Then there are 506C offering syndicates. Now these are the things that Brad Feld, everybody knows who Brad Feld is. He's a venture capitalist up in Boulder, runs the Foundry Group. He put $50,000 into 100 different syndicates. So they form these little groups, and they go out and find companies they can invest in. Okay.
That's like that. A bunch of limited partners.
Yeah. And then look for something. It's like little blind pools. Okay. The problem is that that you can only play in that game if you don't know what you're investing in and you give them the money. you're likely to lose your money. So Brad Feld can do it because he's worth billions, and he can throw $5 million at the wall and see what sticks. But the rest of us have a little trouble with that. It's okay for you, but you're pot luck whether they're going to pick your company or not. Okay. There's also a syndicate group called Founders Club. There's also Angel List. Okay, those are registered investment advisors. They are. Remember, I mentioned the 1940 Investment Advisors Act. Investment advisors are good because they are fiduciaries. They're not like broker-dealers who are not fiduciaries. A fiduciary is like a bank trustee. Lawyers are fiduciaries. You're an agent for your principal. I mean, I work for my clients. I have to do what's in their best interest, not my own best interest. And investment advisors are fiduciaries, so they're supposed to do what's in the interests of their investors and not in their own best interest. Now, a broker-dealer doesn't have that kind of deal. If someone if investment is suitable, and it is within their ability to bear the risk, then the broker-dealer can put you in that investment. And they don't have to think about what's in your best interest or not. It's just what you told them. And I do a lot of work for broker-dealers, and I've done a lot of work for investment advisors. And investment advisors are getting regulated a lot more, but I always feel better working with an investment advisor than I do with a broker-dealer, because the investment advisor knows he's supposed to be doing what his customer wants or what's in his best interest. Okay. 4A6, that's the crowdfunding, and the answer on that one is not yet. Remember, it's not legal yet, the regs aren't right? Okay. That's the statutory section 4A6. These are Rule 506C, statutory 4A6. Rule 506B, remember I mentioned, that's the quiet 506, the old-fashioned 506, where you can sell to 35 or fewer unaccredited investors and an unlimited number of accredited investors, but you've got to have a mandatory disclosure. You have to meet all these checklist requirements. The nice thing about 506, remember, it preempts the states. If you do a 506 offering, the SEC says the states can't stop you from doing that offering. You have to file your Form D gets filed there and with the feds, but 506 preempts the states. So the states can't stop a 506. They will be able to stop a crowdfunding because it doesn't preempt the states. Okay? 506B offering, venture capital, private equity, basically that's the quiet one, VCs. 506B offering, that's on your own. There's not a lot of difference between a 506B online on your own and a 506C general advertising on your own, except you can be proactive, promotional, pushing the actual investment terms with a 506C. Okay, but you still got to, in both of them, you got to verify the accreditation of the people. And what's happened is the 506B quiet exemptions, the old-fashioned 506B, the standards are going up now to meet the 506C ones. Remember, you have to have a system to independently verify. Well, they're applying that to the 506B offerings, even if it's not part of the rule now. So everybody's getting up to you have to Google it, as well as after they give you their questionnaire, you've got to check it, you know. And then I put in Rule 147 offering. It hasn't been on any of my other talks, but the SEC did come out in April with modifications to its Rule 147, which allow it to be used in sales online. Just a little bit about Rule 147. There's a self-executing exemption, again, called, under the 33 Act, called Section 3A11. Okay? 3A11 is for intra-state offerings only in Colorado by Colorado issuers. So the SEC created a safe harbor for that, just so people would be sure they were inside the 3A11, and that's called Rule 147. Basically, the way Rule 147 works is you're exempt from registration at the federal level if you use 80% of the offering proceeds in the state, and 80% of your business operations are in the state. And then you can only sell to state residents. Okay. In the state. The problem with 147 has always been, if you go to the border with Wyoming and you sell offer, you've blown the exemption, okay? So everybody always, if you use 147, the lawyers are afraid of it because it doesn't preempt the states. You got to find your own state exemption. Plus, it's too easy to lose the federal one because everybody lives in Nebraska and you think they live in brush. You don't really know. So, but what they came up with in April is some modifications on the use of websites, on how to validate where people live, and how to limit access to the selling documents to only people who are from certain zip codes and things like that. So there's a way to use that now, but a lot of securities lawyers won't know about it, so you make them go check, make them go look at the regs from this year. Okay. Now, what I don't have on here is these are all exemptions from registration, okay? You can always register your securities. And a lot of people who've gotten frustrated with this, some people who did those crowdfunding portals that didn't get going, were going around Colorado saying, you could do crowdfunding, just register with the state on Form RF or whatever that was, and different kinds of state registrations. The reason securities lawyers don't like you to register, there are criminal penalties for violating the securities laws. A registration statement with the state or with the feds has a long list of what has to be in it. Okay? It's too easy to make a mistake. And with some of these penalties, you don't have to be intentional, knowing, or reckless. You just made a mistake. Boom, they got you. And so no securities lawyers like to recommend that because they like to give you some wiggle room so you can say, hey, I didn't intend to do that. I didn't mean to do that. And so you won't get dinged by the regulators, okay? So we don't like we don't like registration. We like exemptions, okay? And you should too. So, well, with that, I think I've run through my remarks. I had a lot more I could say. In my last page, I've got a bio, but here we are. Comments?
506C,
Yes.
solicitation, is that going to eventually lessen the need for private placement filing?
You still have the disclosure requirements. 10b-5 disclosure. Now,
But I guess it's not private placement anymore, really.
no, they're private placements because 506C was Congress telling the SEC that they have to modify an exemption or create a new exemption like their 506B, the quiet one, for use on the internet. That's what, and so you can do general advertising. Congress made the SEC do this. The SEC didn't want to do this, okay? So the SEC takes the position that 506B, the old one, comes out of that statute. Remember I said 4A2, the offerings not involving a public offering, private placements. But they say 506C, that's a Congress-made exemption. That doesn't come up from the statute. So you've got to follow 506C, the general advertising one, very, very carefully, exactly the way it's written. Because if you screw that up, you don't get to fall back into the statutory power that there's no place to hide. What we like to do, remember I said 147 is the safe harbor from 3A11? 506B is the safe harbor from 4A2. If you screw up the safe harbor, you still can go back to the court cases and say, well, look, just because we didn't get the Form D filed, just because we sold to an unaccredited person where we should have only sold to accrediteds, we're still under the statute, under 4A2. So some lawyer can argue that to a regulator and maybe save the exemption for the deal. But 506C has no statutory place in the 33 Act or the 34 Act. It's just there because Congress shoved it in, and it says it'll be according to rules written by the SEC. So if the SEC writes rules, they get to interpret their rules. So 506C, narrowly construed. 506C doesn't call for certain kinds of disclosure. That's all 10b-5 stuff. It's all securities fraud stuff. But you're never going to get the SEC off the case that if all the material facts, they'll find a material fact that wasn't disclosed. They'll find one, okay? Even if you think you've got it all covered, they'll think that. So you've got to have a disclosure document, because the only reason you use private placement memorandum or business plans or something is so all the investors have the same belief in the same story. You know, if you tell one guy one thing and one guy another thing, it doesn't work because everybody gets the same offer in the same offering. I can't tell you I'm going to use the money to go to Mexico and tell him I'm going to use the money to go to New York, okay? That's inconsistent. You've got to tell them both the same thing in the same offering. So I'm just...
When did that go into effect?
506C, September 23rd of last year, of 2013.
So I'm an inventor. I'm going to raise money. Is there any way I can solicit unaccredited at all? Any idea?
Well, you can't you can, okay. There are,
But what about subchapter S? There's a limit on unaccredited.
that's a tax rule. Those are tax rules. There are only 100 investors, but that's a tax. That has nothing to do with securities law. Sub S says you can have up to 100 individuals investing in your company. You'll still be taxed as a pass-through entity. It's not a security.
Like 35 unaccredited in that group?
No, that's not under subchapter S of the Internal Revenue Code. The 35 only relates to the quiet exemption 506B, the old one. Okay, there are state exemptions that move around, and some of them are at 20 and some are at 15. But remember, 506 preempts the states. 506 preempts the states. So the 35 sort of dominates everything.
I think I remember. It's usually like an employee of the syndication.
There are other exemptions. There's a 901. There's 701 and 901. 701 sell only to employees for a offering plan. Other kinds of accredited investors, by the way, are officers and directors of the issuer. Those are accredited by definition. Not thinking about natural persons, and that's not relevant to this. But if I have a corporation with $5 million in assets, or a bank, or a savings and loan, those are accredited investors. There's other exemptions. There's 504 is an exemption. You raise up to $1 million in a 12-month period. It doesn't preempt the states, so you have to find an exemption in each state where people live. And I mean, 98% of all the Form Ds that are filed, Form D is for Rule 504, 505, and 506. 98% of all of them are 506. Everybody uses 506 because it preempts the states. So the goal.
If I'm starting a company and want to raise money, I really can't solicit unaccredited if they're just a pure.
Look, you can solicit anybody for anything. Doesn't matter.
Legally.
Well, yeah, but you just can't do it generally. I mean, I can walk down the street and I can say, Joe, would you be interested in investing in my deal? You can do that. That's not general advertising. You just one-on-one. Okay, you can go to the church that you belong to, and you can't stand up in front. Okay, but you can stand in the back and talk to them one by one as they walk out. It's the difference between general advertising and a general solicitation and one-by-one solicitation. You can't leaflet all the cars in the parking lot. Okay, but you can give a leaflet to each guy that goes by. Okay. You cannot put an ad in the newspaper, okay? You can't put an ad in the newspaper, okay?
And that would be
The definition of general solicitation has come back into discussion in the last 2 years. We never talked about this for 20, 30 years. Nobody talked about general solicitations. The problem with general solicitations is that there's no definition of public offering in the securities laws, okay? And yet I just told you about 4A2, it's for offerings not involving a public offering, or we call them private placements, but it's offerings not involving a public offering. And when you do a registered offering, by definition, you are doing a general solicitation. You're handing out prospectuses that are filed with the SEC to everybody and their brother and putting big ads in the newspaper and using broker-dealers. Now that's a general solicitation, okay? So the SEC had a real trouble with letting people do general solicitations for securities raises that weren't registered with them, what they hadn't vetted, that they haven't looked at all the documents for. So, and remember, this is their own little Congress-made exemption here, this general exemption, this 506C general advertising. So we're all in here now trying to figure out where the lines on a general solicitation versus a not general solicitation. Solicitation per se is just to advertise. I mean, you can do things, you can't do things, okay?
Can I go on the street and meet someone I don't even know? It's a one-on-one and I can.
Yep, but you cannot yell it in a crowded theater. General solicitation, you can't do that.
But I can go up to someone I don't know. And
Well, do you have look, when you do a 506 offer, a 4A2 offering, a private offering, okay? The court cases, not the safe harbors, that the prospect, the person you're going to talk to, has to either be sophisticated or have the ability to bear the risk. And the purchaser has to have both. Remember? So, and if of the 35 unaccredited we talked about, if I think you're sophisticated, like, I don't know, coat and tie, nice house, whatever, I can see if you're interested in the investment, okay? But you have to have the ability to bear the risk of loss if you are sophisticated. You still have to have the ability to bear the risk of loss. The court cases say that money means access to information. Ralston Purina, the only court case interpreting the private placement exemption, says that money means power to get information for yourself. So if you're a billionaire, by definition, you're not going to get ripped off. Or we don't care about you if you do get ripped off because you should have known better, okay? But the widow with 4 kids, who's worth $5, I mean, the average black woman in America has a net worth of minus $5, okay? So she's got, if they want to get her to give half her paycheck to invest in something, they really want to protect those people. That's how the securities regulators think. So you've got to reasonably believe that they're sophisticated or have the ability to bear the risk before you can talk to them, and you've got to believe that they have both before you can take their money. Okay, we're not talking about accredited investors. We're just talking about the old rules, and they still apply. Now you're supposed to have a prior existing business relationship. The court cases don't say that. The SEC says that. So. And Justice Scalia just came out with a little something that said, look, the SEC is not entitled to any presumption or deference when it comes to interpreting the federal securities laws. It makes them crazy, because that's all they do every day is interpret the statute. And yet their interpretation is no better than mine, according to Justice Scalia, and he and Thomas joined. So there's at least 2 Supreme Court justices who say the SEC doesn't know any more than I do when it comes to talking about the 33 Act, or the 34 Act, or the 40 Act. Now, they know more about their regs, but it's I'm playing this game all the time. It's pretty fun to be in this place. Okay.
so if I solicited someone one-on-one and I had a reasonable belief, they're not accredited, that they're an experienced business person in, say, my field, and they seem to be sophisticated and successful, then I'm probably good.
Well, you want to give them a questionnaire. What we always do, what we've always done, securities lawyers, is use a investor suitability questionnaire. And that is, do you own your own house or do you rent? How many investments have you made in the past 5 years? What kind of investments have you made? Give me a copy of your tax returns. A lot of information trying to glean that they know what they're doing A lot of times they put not applicable, or they don't give you a lot of stuff like that. But at least you tried, okay? But I'm just helping the issuer. It's the issuer's the guy going to jail, not me, okay? So there aren't criminal penalties in this area, but basically, to get it off the ground, you should know who you're investing with, who's investing with you. Excuse me. So,
And that's the prior relationship, which
a prior business relationship.
is a practical thing, I guess.
It is. I mean, I'm going to sneeze again. This is getting to me. But like these broker dealers that went out and they get lists of broker dealers, get these lists of accredited investors, you know, and that allows them to say that they have a prior existing business relationship. They don't invest in the first deal, but they can go after them for the second deal. Now that's only for broker dealers. If I'm an issuer and they don't invest in my first deal, then I can't use that as the prior existing business relationship to go after them for the second deal. There's a lot of games in this world.
As soon as you've done one deal, you're good.
Sure, but you got to get that first deal done. That's the hard part. So if I'm an investor, if I'm a inventor, what I would do, I form a little entity, form a LLC, limited liability company. Check the box down at the Secretary of State's office. Okay. Then go family, friends, you know, the people you know, see if they're interested in your invention, and give them a piece of the LLC, you know. And that's the type of an entity that's the easiest thing to set up.
And it's okay if I give them a piece of the LLC, and they just get a share distribution, but they're not actively involved in it?
Sure, that's okay. But if you want to give them a security, if you don't want to give them a security, then you need to make everybody a general partner, and everybody's generally at risk, which they usually don't like, okay? And everybody's involved in all the business decisions, which they usually don't want to be involved. They could care less, okay? They trust you. And they trust you till they don't trust you. That's the problem. Then they forget what they were trusting. And they come and blame you, okay? I'm doing a deal right now for a 501c3 nonprofit charity, and they want to go out and take money from people, a loan, interest-free loan for 2 years, and then they'll give it back. I said, well, okay, what are you going to do with the money? Well, we're going to loan it out to these other people at an interest rate, you know,
They're like a bank.
to start up small businesses, yeah. And I'm sitting here thinking, well, wait a minute, is this a security or not, okay? Well, usually, you heard my definition of what is a security. It's expectation of profit, you know. Well, there's no way to profit from this, but you could lose it all. And I keep asking them, well, what's going to happen if you lose all the money? Oh, we won't lose them. Well, what's going to happen if you lose all the? How are you going to pay them back if you can't get it out of the company, the other nonprofits you invested in? You know, it gets a little narrow in there. I think I wouldn't do it. He's willing to go ahead and do it, so I'm sort of backing away from it. But he's doing that on the internet. There's a site called Kiva, K-I-V-A. That's things like this. There's 200, 300, 400, 500 websites. So you've got to know what website you're working with. I wouldn't go in this area without knowing whether you're working with an investment advisor or a broker-dealer or a funding portal or an aggregator. I mean, you got to know what you're dealing with out
It
there.
almost seems like a syndicator, like they're gonna form a limited partner fund.
Yeah, yeah.
Pooling money. But those limited partners, they all need to be accredited, right?
Yes.
Okay.
Yeah.
Please tell my ass.
Well, we don't have to stay here all night, you know. But are you getting a sense of how it's tough when you're just an inventor and you gotta, you know, it's easier if you get a partner and form an entity. There's a belief that the inventor in and of himself won't have good judgment. He'll be too biased towards the invention. Okay, so you need a doctor no, the partner who says no, we didn't say we'd spend the money on that. Said we'd spend the money on this, and we have to stay on the plan. Sock, and that's tough for inventors, okay, because I worked with a lot of inventors back in the day, and, you know, they know they're going to win everything, but it's hard to,
They don't wanna let
Well,
more control and
sure. People always overvalue what they bring to the table. The money guy values the money. The guy who does the work values the work. The one who brings the intellectual stuff values the intellectual stuff. So it's a compromise, you know. There are sort of checks and balances. Any other questions? We got a full basketball team out there. We're doing well. Well, okay.
is anyone here gonna think about fundraising or planning in the future?
Yeah. Well, I'm happy to have you give me a call if you need. I'm happy to give advice all the time. It's always good. Roger's a solid citizen on the IP stuff, so that's good. Thank you. Good stuff.